Mr. Pansel to go forward on his claims. Thanks very much.
Thank you, counsel. All right, the court will call the next case Allied Aviation, LLC et al. Versus ASIG Holdings Corp. et al. All right, 5 minutes for rebuttal adequate, or do you want a different amount on the clock, sir?
5 minutes is fine, Your Honor. Thank you.
All right, sir. Fire away when you're ready.
All right. May it please the court, my name is Tucker Bird, and I represent the appellants, which I'll call collectively Allied. This case serves as a...
Is Ethan Allen still the law in Florida on intentional or interference with an advantageous business relationship?
I believe it is, Your Honor.
All right. One of the elements is that it has to be a prospective, existing or prospective relationship under which there are legal rights. Do you agree with that?
I agree, Your Honor. I think that's an accurate statement.
So in this situation, your clients, as I understand it, were on a month-to-month. At the end of the long relationship, they were on a month-to-month contract. Is that right?
They were on a month-to-month relationship in anticipation of a long-term contract.
Well, I mean, but they had a month-to-month contract. Just follow me on this for a second, Mr. Bird. Is there an allegation that the month-to-month contract was breached?
No. In fact, the allegation is that they were precluded from getting the long-term contract,
Okay.
which would have been the logical conclusion.
And you contend that they had the legal right to that long-term contract?
We believe we had the legal right to not be unreasonably interfered with getting that contract.
Did you have a legal right in that expectancy?
I would say a legal right in the expectancy, in that expectancy can be protected. Not a contractual right, as in we had the right to make the airport, the Tocumen Airport, give us the contract. Certainly not that.
Well, all right, just hypothetically, had there been a third bidder, so there's the plaintiff bidding, the defendant bidding, and there's a third bidder who has no relationship to either the plaintiff or the defendant, and the facts had unfolded as they did here, which is that the defendants won the contract. Would this third party have a right of action for tortious interference with a prospective business relationship?
Well, in order to answer that question, Your Honor, you would have to posit that that third party was positioned the same place our client was.
No, I wanted to posit that the third party was in a different position, that the third party was, walked in the day after the contract went up for bid and didn't have any prior relationship with anybody and no connection with anybody, and went through the bidding process and lost because of the alleged illegal actions of the defendant. Do they have a claim for tortious interference?
I think they would have to prove that it's more likely than not that they would have gotten the contract.
So you think that even though all they are is a bidder and they have no expectancy other than a hope that they're going to get the contract, that arises to the kind of business relationship that Ethan Allen speaks to that gives them a right to sue for tortious interference?
Well, not that particular hypothetical party, because they would have to prove that more likely than not they would have gotten the contract had it not been for the improper interference, which in
How
this...
is that any different than we have lots of these situations where we have these terminable at-will employees who, I have a law clerk that's worked for me for 13 years, and I suspect that if you asked her, that she would have every expectation that she's going to continue to work for me next year, but she's a terminable at will employee. If some third party came in and told me a bunch of lies about her and caused me to fire her, would she have a claim against that third party for interference with an advantageous business relationship?
I think so, correct. I do.
Case law is against you on that, Mr.
No,
Byrd.
but actually, with all due respect, I would submit that if the plaintiff can prove the reasonable likelihood that it would have benefited from the advantageous business relationship, but for the improper interference of the
You
tort.
got a Florida case that says that that's actionable, the hypothetical I just gave you, because there's plenty that say it's not.
I think it's inherent, Your Honor. The whole concept of an advantageous business relationship is not that you have a contract, that you have a reasonable expectation of that relationship, coming into fruition to create something of value.
Well, you've read Ethan Allen, I assume.
Sir?
The Ethan Allen case, you've read
Oh,
that.
absolutely.
Yeah. Ethan Allen, the Florida Supreme Court, divided it really into two different types of claims. One that had to do with the existing contracts that the furniture store had with existing customers to buy furniture, and the other was the expectancy that they had that they were going to be able to sell to these past customers in the future. And the Supreme Court said that that's too attenuated.
But the problem with Ethan Allen really stands for the proposition that you don't have an expectation with the world. That's not what we have here. We have an expectation of a specific contract with a specific party, the Tocumen Airport. So in that respect, this is not an Ethan Allen case. This is not that somebody would have done business with us. This was an actual contract. In fact, we had this relationship. And but for the...
You had the relationship, and you knew that it was month to month.
Well, we had 17 years of relationship.
That's wonderful. That's just like my law clerk. She's had a 13-year relationship with me. But you say that's actionable, so... okay.
With all due respect...
Let me move you ahead to the
right, sir.
next point of inquiry that I have. And that is about the unjustifiable nature of the interference. You acknowledge, do you not, that the interference has to be unjustified?
Absolutely. I think it's an element of the tort, correct.
And, legitimate competition is not unjustified.
I would, by definition, I would accept that definition, yes.
All right. And I think I've seen some cases that say that what unjustified means is that it's not sanctioned by the rules of the game, right?
I think the mores of the marketplace.
Say again?
The mores of the marketplace.
Okay, so now is that, in this case, in your case, is that an issue of Panamanian law, or is that an issue of Florida law, or what law controls what law controls the business standard by which this conduct is measured?
Florida law. This is a Florida tort. It was a tort that emanated...
Well, okay, all right, I assumed you were going to say that. So let's say that these business dealings are going on in some third world country where bribery is sanctioned by the business community. It's part of the game. It's part of the rules of the game. Just assume that hypothetically. But yet, somehow Florida courts get jurisdiction and a Florida tort is alleged in a suit for interference. It is not, under my hypothetical, if bribery is sanctioned and is appropriate in the jurisdiction in which these business enterprises and this business is conducted, does that not take it outside the unjustified element?
Take it out. I think it's actionable, if I understand the question.
You do think it's actionable?
I'll give you an
We're
example.
playing by the rules of the Florida game, even though we're playing the game in a jurisdiction where the rules might be different.
I'll give you two examples. On the federal arena, by analogy, you can have bribery may be legal in a country, and yet you can still violate the Foreign Corrupt Practices Act.
Oh, sure.
That's actionable in the U.S. If you have a bribery which originates from Florida, and I'm going to call it bribery because that's what we've alleged, something like that, emanating from Florida, that's where the tort originated from, the injury is felt here, I think it's actionable here. And that's, of course, that's one of the problems of relying upon the Panamanian decision under the procurement law. And that's why, in fact, You cannot take the Panamanian result, whatever it is, and then map it over here, assuming you can even get by the privity argument, which I'd like to address next.
And I'll let you address that in just a minute. I just want to follow through with this line of questioning. You had to establish unjustified interference, right?
I believe that's correct, yes, sir.
So why is not the judgment in Panama res judicata as it relates to whether or not what they did was legal?
Well, first of all, the interference, that the way you phrased it, was not adjudicated in Panama. The Panama decision was based upon a Panamanian concept, I believe it's under the code, of transparency and registration. They're technical violations that address whether or not our client could be dispossessed on the lease.
But res judicata does not confine itself to the issues that were actually litigated. That's what collateral estoppel is about, right, Mr. Byrd? Res judicata has to do with not only what was litigated, but what should have been litigated. Right?
Well, certainly the concept of res judicata is broader, but that's why you start with the issue of privity. There's no privity between the defendant or defendants in Panama and the defendants in this case. That was one of the fundamental problems with the lower court's ruling.
But you did litigate, or you should have litigated, the issue of whether what the defendants did was illegal in Panama, right?
Well, you'd have to.
I mean, that was teed up for the Panamanian court to decide.
Well, you'd have to assume that the tortious interference is a claim even in Panama. There's no indication of that.
But res judicata has to do with taking something that was adjudicated in one place and
correct.
And applying it to something different. If it was as easy as suing for defamation here, then suing for tortious interference here, and then suing for breach of contract here, people could get away with that all the time, right? I mean, it's not as easy as what did we sue for. The question is, was there an issue adjudicated, or was there an opportunity, should the issue have been adjudicated, which bears on the claim that you have now brought? And you brought a claim that requires you to prove that the interference was unjustified.
Correct.
Okay, and your claim is based on the illegality of the bidding irregularity that went on. Not correct. Not correct.
Not correct.
Bribery's not part of your claim?
Well, I'm defining illegality as in violating the code down there of transparency law and registration. That's the difference, you see. The claims based here are Florida-based tort claims that emanated from Florida. And of course, all of this analysis about res judicata really begins, of course, with the concept of privity. Is there privity? And this is where I believe the lower court simply missed the boat, and that is, privity by definition, generally speaking, is a concept of association or control. There are lots of different tests out there. One test suggests that...
Now, is this the identity of the parties element that you're talking
correct.
About, that privity bears on?
No, because it wasn't the actual same party, so you have to resort to a privity.
So the question is whether or not the parties are in privity.
Correct. That's correct. One case, for example, says that the party outside Panama, in this case, the defendant in this case, could have had a seat at the table in the Panama case. Now, just hold that for a minute. Imagine that the proceeding down there on a wrongful eviction from a property. What role?
More than that, Mr. Byrd, right? It was not just wrongful eviction, it was also money damages.
Well, sure, the ultimate result is, can you be made whole? You can be made whole from two different causes of action from different parties. You're only allowed to be made whole once, obviously. But you couldn't say that the defendants in this case would have had a seat in that litigation. Furthermore,
your clients, they have a dog in the hunt, obviously, or they wouldn't have a claim for damages, right?
Correct. Well, that's why res judicata, you have to look at, well, is an adjudication against that party? Does that map over and apply against the claims against this party? And, the parties...
Do they have distinct damages? Do the plaintiffs in this action have damages that are distinct from the damages that the plaintiffs in the Panamanian suit have?
Could have, yes, absolutely.
Could have?
Yes, sir.
Yeah.
Well, the whole idea is...
entirely overlapping. I mean, the claim down there was that their business opportunity was destroyed and they lost that opportunity, and the claim here amounts to essentially the same damages, right?
No, because what could happen, for example, is this. What happens if, in fact, the eviction down there was set aside, and they were restored into possession? There may have still been a damage.
But they brought an alternative claim that, for damages, assuming that that allegation for damages was for the whole lost opportunity, wasn't it?
But they're different. They arise from different legal elements, from different sovereignties, for that matter. And of course, that's one of the issues. Remember, the second issue, of course, is there has to be identity of the causes of action.
If they're the same damages that all of these entities are pursuing, albeit in different actions, doesn't that essentially suggest that they have identity?
Absolutely not. In fact, that stands the concept of identity of the parties on its head. You could be damaged by different parties under different theories. You could suffer only one economic loss, but in fact, you have different legal concepts. There's no showing in here that we could even have sued the defendants in this case down there. This court's ruling, the lower court's ruling, if it stands, means that we had no day in court against these defendants. This issue of the tort, this issue of the interference has not been litigated. And I see that I'm into my, 4 minutes left. Which leads me to...
That is your rebuttal time.
I'm in rebuttal time.
You are in your rebuttal.
All right.
It's your time, though, so use it.
Well, you know what? I think I've saved it for rebuttal because I anticipate the questions that will be asked.
All right,
Thank you, Your Honor.
sir.
All right.
May it please the court. Michael Levin, representing the appellees.
Mr. Levin, can you help me understand? I looked at the judgment, the translation of the judgment in the wrongful eviction damages case.
Yes, Your Honor.
There's also references in the documents to the Public Procurement Tribunal and those activities. Can you tell me what the record reveals about what the claims were that were adjudicated by the Public Procurement Tribunal?
There were multiple, let me go back. The award was made November of 2010. The award is
the contract award?
The contract award was November 18th of 2010. The translation is attached as an exhibit to the operative pleading. Thereafter, Allied and Ogden unleashed a spasm of litigation down there, including claims in the Public Procurement Board down there challenging the bona fides of the bid award. So those were separate proceedings that ultimately several different proceedings were filed against the airport, against ASIG Panama in Panama. That's separate from this judgment. This case that was filed down there, the best and dispositive characterization of the case down there is what the plaintiffs said when they came into federal district court and filed a Section 1782 proceeding in order to gain discovery for use in Panama. So they were required to characterize their claim. And if you read that Section 1782 application, which is part of the record which judicial notice was taken of, it describes exactly what they're seeking here. There are paragraphs in the Section 1782 application that are verbatim from their current operative pleading. There's even a greater similarity to the pleading that existed at the time, which I think was the amended complaint. So what was sought was a cause of action for damages that for the loss of the contract based upon illegal conduct. That's what they said to the district court as when they characterized it. It's in paragraphs.
That was in relationship, though, to the claim that resulted in the judgment that we read that was annexed to the complaint. Is that right? In other words, the wrongful eviction and damages claim.
The judgment attached to the Rosa Restrepo affidavit.
Right. Okay. What I'm trying to figure out is, what does this record tell us about what the Public Procurement Tribunal was asked to adjudicate, and what did they adjudicate? Just based on the name, I'm assuming, although this is why I'm asking you to point me to the record where it'll help me, if you can.
I don't
I'm
bel-
assuming it's some kind of a bid challenge that they are complaining about, that the bid wasn't done in accordance with Panamanian regulations, and I'm just trying to understand if this record will reveal anything about what the Public Procurement Tribunal is and what they did.
Your Honor, I know the answer to that question, but I don't believe it's in the record, so I won't reveal it today.
Okay.
What the record does reveal is that there were multiple.
So your claim of res judicata was not predicated upon any disposition done by that tribunal? It was based on the judgment entered by the Panama Court.
The final judgment entered by the First Judicial Circuit in Panama. Now, it was characterized.
Now, going to you raised collateral estoppel and res judicata.
Yes, sir.
Affirmative defenses, right?
Yes, sir.
All right, and you won summary judgment on both of those.
Yes, sir.
All right. Is collateral estoppel in this case, does it apply to matters that were not actually adjudicated in the Panama case?
I agree with Judge Munyon that if you look at what was the issue in the case, it's the identical issue, a claim of improper conduct. Now, whether it's presenting and conspiring with the Board of Document to use an improper bidding award process, or whether it's where they were raising this issue of a bribe.
Mr. Levin, just as a legal proposition, doesn't collateral estoppel only address itself to issues that are actually adjudicated,
I believe that,
as opposed to what could have been or should have been, like res judicata?
well, it's not actually adjudicated, actually raised. So if you raise an issue.
Well, the trial judge down there disposed of the case on statute of limitations grounds, right?
Yes, sir.
Under some innocuous statute of limitations in Panama that, talks about negligence and talks about something else. I don't know. I couldn't really understand it, but it was a 1-year statute of limitations. There was a 6-month limitation on the eviction, and there was a 1 year on the damages claim, right?
I believe so.
Supposing that this tort, which, we know under Florida law, this tort is a 4-year statute of limitations. How does collateral estoppel preclude them from bringing a claim on a tort that is a 4-year statute of limitations, assuming that they brought it within time?
I believe that the concept of collateral estoppel applies to the issues actually raised. I think collateral estoppel applies to prevent a tortious interference claim. Let's use a domestic example.
You don't think that the court, if the court had said, we agree that it was illegal what they did, but you lose under the affirmative defense of statute of limitations, that collateral estoppel precludes them from relitigating the issue of the legality of the actions?
They don't have to agree that it's legal or disagree. They can find the statute of limitations barred it. If Allied sued in Brevard County for tortious interference, and it was resolved by statute of limitations, and then they try to bring a claim in Orange County, collateral estoppel would bar that because it was raised. The difference is res judicata applies to everything that could have been raised. So I believe that Judge Munyon correctly applied collateral estoppel as well, but res judicata, I think, is dispositive in this case. I would like to briefly address the privity issue. We've briefed it extensively, and what was not addressed on my colleague's presentation is that they pled the actual allegations of their more definite statement of Fourth Amendment complaint, their operative pleading, pled factors that are well within the concept of privity as understood by Florida courts. So those paragraphs were set out in full in Judge Munyon's order, and I think that's dispositive. In the reply brief, there was an effort to make a distinction to claim that the defendants and appellees in this case were joint tortfeasors with the Panama entities. if you review the operative pleading, there is no allegation that the defendants in this case were joint tortfeasors with the defendants in the Panama case. Instead, there's a conspiracy claim where it is said that the appellees conspired with known or unknown persons. Well, ASIG Panama and Consortium ASIG Panama are not unknown persons. They know them, they sued them. So there is no allegation of joint tortfeasors, and that's not a basis to get around the privity requirement. I think the identity of causes of action element is satisfied conclusively by both the fact that they both sought the same damages, as has been just discussed, and the characterization of the claims in the Section 1782 claim. There's been an issue about whether there's been an adjudication on the merits down there. Clearly, there has been. The affidavit of Ms. Restrepo, which was uncontradicted and not challenged, said that it was a final judgment. Now, we're not required to entertain a complete exposition of Panama law about what constitutes finality. Said it was a final judgment. They could have arguably taken Ms. Restrepo's deposition. They could have submitted a contravening affidavit. They didn't do any of that. That's the record we have, and the record is it was a final judgment. So the adjudication of the merits was established. In the briefs, and I'll cover this briefly, there's a argument about whether Panamanian preclusion law should have been asserted. We addressed that issue in our motion for summary judgment. We found that the case law was conflicting about which preclusion law you use. It's footnote 9 to the motion for summary judgment, and applied Florida preclusion law. The motion was argued based on Florida preclusion law. There was no objection to that. The only basis in the record that was cited about objecting to the use of the Florida preclusion law actually relates to the question of whether there was an adjudication on the merits. So absent an objection to that issue in the trial court, all the briefing about Andahar and those issues about using a different preclusion standard should not apply. If the panel has no other questions, I'm going to sit down.
All right, sir, thank you. Anybody
very
got a
much.
question? All right,
Thank you for your time. Good seeing you all.
all right, thank you. I would have given you some extra time, but he left 9 minutes on the table, so you're going to be stuck with this. I'll do my level best to refrain from interfering with your next 4 minutes and 16 seconds.
I always have practice.
Use it wisely.
I'll entertain any questions the panel wants to ask. Let me talk briefly about what I think are some highlights of this. Number one, the lack of privity. You notice he said, we asserted the existence of privity in our complaint. We did not. What we alleged is that they were affiliates or subsidiaries, which is not privity. They denied it, by the way. They've denied it every step of the way. They denied it so far to ward off discovery because they were not in privity. So for them to come around now and say they're entitled to privity is, I think, is an inconsistent position, what we call flip-flopping, I think, in most quarters. The second, so which means they're left with collateral estoppel. And again, getting back to this idea of the identity of the causes of action, what does that mean? What you'd have to say is what was tried in Panama is identical to what was tried here. We know that's not the case. Panama, it dealt with the Panama statute. The Florida case deals with Florida causes of action. For all we know, what they did was legal in Panama. It doesn't mean that it's not illegal what they did here. And, Your Honor, you mentioned the idea that there's this overlap. The overlap of facts is not enough. You know, you can't, it's just the mere fact there's an affinity or that you're trying to be made whole. You can be made whole for different theories and causes of action. The next question is, was it fully litigated down there? Fully litigated. We know the tort claim was not litigated at all. It was not even raised. Is it final? They mentioned the Restrepo affidavit. The Restrepo affidavit talks about a historical record, but it doesn't talk about the effect of what that is. Is the record clear about what really happens? What really is the preclusive effect of a Panamanian judgment? Does Panama have res judicata? Does Panama have collateral estoppel? The law is clear. The law of the rendering court determines the preclusion rule. And that's the Andahar decision, which means they would have to apply Panama preclusion rules, this court would, in order to ascertain whether or not there's any preclusion. By the way, they bear
Was the trial court informed of what Panamanian preclusion law is?
The trial court was not told one way or the other. The question was asked by us. We asked it, is there any showing? How do we know that the Panama court ruling would have any effect? We kept asking that with the trial court. They say we invited the error. They identified in their own motion papers, they called it unsettled. The law is actually very clear. You have to apply the preclusion rules of the rendering court. This court sits de novo. It certainly can look at it and say, well, what was the preclusion rules? And by the way, if in fact the law were clear on it, I would expect their brief before this court to scream out what the law is. Here's the law. Nothing. Silence. I think that's indicative of a lot. We certainly didn't waive it. So I'll conclude with this comment basically. The fundamental question is this court ceding the disposition or control of a Florida case between Florida litigants over a Florida tort? Is it going to cede the outcome of that to a Panamanian court? We're not asking for the proverbial second bite of the apple. I mean, we're not. All we are asking to do is at least be allowed to enter the apple orchard so this case can be litigated. We think that the trial court ought to be reversed respectfully and remanded. Thank you.
All right, thank you, sir. Thank you all.